This session is about the relationship between competition law and other legal frameworks, in particular data protection law. If we start from the premise that data, in particular personal data, confers a form of power over individuals, and this, I think, has been a long-standing premise of privacy and data protection law. Think of the way in which the FBI used information about Martin Luther King in order to blackmail and to control him. And we can fast forward and think of the way that modern digital platforms use information about their users in order to shape the preferences of those users and to sometimes exploit their vulnerabilities. Well, this form of data as power is implicitly recognized in data protection and privacy frameworks, and is also now increasingly recognized in competition frameworks. So competition law thinks of the way in which data control gives businesses power over their business users, but also over their end users. So we can see a complementarity in terms of the objectives of these legal frameworks. And in this session, we'll explore the ways in which synergies between the legal frameworks can be promoted. So we might think of the way that competition law's merger control policy could be applied in order to enhance data protection. Imagine a world where Google was not allowed to acquire Fitbit, or where additional conditions were imposed on that transaction in order to promote and effectively ensure privacy and data protection. But also to ensure that competition law is not applied in a way that negatively impacts data protection and privacy. So if we think of the data sharing obligations that you see in new EU competition proposals like the Digital Markets Act, we could imagine that data sharing could be applied in a way that negatively impacts privacy and data protection. In this session, we want to think about how best to harness competition law in a way that effectively promotes digital rights. The terrain on which we fight for digital rights has shifted. It's no longer simply looking at digital rights frameworks like the data protection regime. We now increasingly see digital rights issues arise in other contexts in the competition setting. So a good example here is merger control. If we give companies a blank check when a big digital platform like Facebook, for instance, acquires WhatsApp, or Google acquires Fitbit, then this can negatively impact on principles of data protection and privacy that we've fought for years, like data minimization or maybe even purpose limitation. More recently, you could think of examples like the way in which Apple's attempt to prevent cross-party tracking through its apps has been is being investigated as a competition infringement. And there, privacy and data protection, GDPR compliance, is being invoked as a defense before competition authorities. When these types of data protection issues are being invoked and litigated in competition settings, it is critical that we have digital rights organizations with expertise in these areas in the room in order to advance the cause of digital rights. The risks are that we have multiple agencies, competition agencies, data protection agencies, public-private enforcement. We have all of this ongoing at the same time, and that we have conflicts between the various decisions that are adopted and various litigation strategies. In a worst-case scenario, this could increase the costs of those interested in strategic enforcement, and it could lead to more opportunities for regulatory capture. So there are definitely risks here. But we are also at a point in time where the opportunities are large. We have increasing recognition from various regulators that cooperation between them is necessary. And some are even recognizing that beyond cooperation, these agencies now need to work in a way that recognizes their interdependence. And here, so that's, I think, from the institutional perspective, an opportunity for a more coherent regulatory and legal framework for the digital environment. From a substantive perspective, we have various new legal instruments that are about to be adopted that will, in their first years of application, need a lot more finessing. And I'm thinking here in particular of the Digital Markets Act. This is a kind of a sui generis legal instrument insofar as it's not pure competition law. It also aims to ensure the fairness and contestability of digital markets. So these are not the kind of mainstays of competition law. And here there's really an opportunity for digital rights organizations to have their voices heard and to ensure that these instruments are applied in a way that effectively advances the cause of digital rights in Europe.